I had been sitting in that chair for 11 minutes, and I had counted every one of them. The conference room on the 4th floor of the Harmon building smelled like carpet cleaner and old coffee, and the fluorescent light above me kept making a sound like a moth bumping against a window screen. My second wife's attorney was standing at the far end of the table, shuffling papers and glancing at me the way you glance at something on the bottom of your shoe. My wife, soon to be my ex-wife, sat beside him in a pale blue blazer I had never seen before. Her hair was different. Her posture was different. Everything about her had been recalibrated for this room, for this moment, for the performance of winning. I was wearing a flannel shirt I had owned for 9 years. It had a small pull near the second button. I had debated wearing something else that morning. I had stood in front of my closet for a long time. Then I put on the flannel shirt. The attorney, a man named Pierce, set down his papers and looked at me with something between pity and entertainment. "Mr. Calloway," he said, "I want to be straightforward with you. You're not represented today. That's your right. But I would encourage you to think very carefully about what you're walking away from here, because what we're prepared to offer is, frankly, more than generous given the circumstances." I nodded once. I did not say anything. My wife looked at the window. "The property at Dunmore Lane," Pierce continued, "was purchased jointly. My client contributed substantially to its maintenance and upkeep during the course of the marriage. The court will recognize that. What we're asking is straightforward. What he was asking for was the house. The house where my granddaughter had slept in the same room for 6 years. The house where her shoes were lined up near the back door and her drawings were taped to the refrigerator and her bicycle was leaning against the wall in the garage. I folded my hands on the table and waited. Pierce looked at my hands. Then he looked at my shirt. Then he looked at my wife and something passed between them, a small current of shared amusement, the kind that people share when they believe they are watching something inevitable. "This doesn't have to be difficult," he said. "You're a retired man. A pension. Some savings. That's not nothing. But the asset in question is the home, and my client has an equal claim." I thought about saying something then. I thought about a lot of things. Instead, I looked at the light on the ceiling and listened to it hum. I had not always been easy to underestimate. I retired from the county at 61, 31 years as an electrical inspector. I was not a flashy man, and I had never wanted to be. I grew up in Garfield County, Kentucky, the son of a man who fixed small engines and a woman who worked checkout at a grocery store that no longer exists. I understood early that work was not something you performed for other people. It was something you did because it needed doing. I met my first wife when I was 24. We were married for 26 years. She died of pancreatic cancer the February before I turned 53. Her name was Ruth, and I do not talk about her much because some things are too solid to describe. My daughter, Claire, was 31 when her mother died. Claire had always been the kind of person who struggled to hold things together, not because she was weak, because she felt everything at too high a volume and had not yet found the dial. She had a daughter of her own, Maya, who was 2 years old when Ruth passed. Claire's situation was complicated. Her relationship with Maya's father had ended badly. She was working 2 jobs and trying to keep an apartment and doing all of it without a safety net. So Maya came to live with me. That was never a formal arrangement. There was no paperwork, no court order. It was just what happened. Claire was still in Maya's life, driving down on weekends, calling every night before bed. But the day-to-day fell to me, and I discovered that being a grandfather raising a small child in your mid-50s is one of the strangest and most clarifying experiences a person can have. You stop performing. You stop having opinions about things that do not matter. You wake up at 6 in the morning because someone with syrup on her pajamas is standing next to your bed asking whether butterflies dream. I met Sandra 2 years into that. She was 54, recently widowed, working as a property manager for a company based in Ashton. She was put together and quick, and she laughed at things I said that were only slightly funny. We dated for almost 2 years before I asked her to marry me. Maya was 4. She called Sandra by her first name, and Sandra was kind to her in the competent, organized way that some people are kind efficiently, with appropriate gestures. I thought that was enough. I had not been looking for Ruth. I had stopped looking for Ruth the day we buried her. I was looking for something sustainable, something decent, something that would give Maya a home with 2 adults in it. I told myself that was wisdom. I know now it was loneliness, dressed up in sensible clothing. The marriage was all right for the first 4 years, not exceptional, but all right. Sandra was organized and had opinions about curtains and kept the kitchen clean in a way I had never managed. She and Maya were not close, but they were not unkind to each other. They moved around each other the way people move around furniture they have accepted but never quite chosen. It was in the 5th year that things began to shift. She started working later. Not dramatically, not all at once, but gradually, the way water finds its level. She joined a professional association that had monthly dinners. She began referencing a developer named Gary Whitfield in the way people reference someone they think about constantly while attempting to appear casual. He was building a mixed-use complex on the north end of town. He was, Sandra told me more than once, very forward-thinking. I did not say anything about what I noticed. This is a flaw in my character that I have made my peace with. I observe things and I let them settle, and I wait to understand what I am looking at before I speak. Sometimes that is prudent. Sometimes it allows things to go on longer than they should. The confirmation came on a Thursday evening in March, 2 years before the conference room with the fluorescent light and the moth sound. I came home from a walk earlier than expected. Sandra's car was in the driveway. There was another car I did not recognize. I stood in the backyard for a moment. Then I went inside through the front. I will not describe what I found. It is sufficient to say that I understood immediately and completely. Sandra tried to speak. I raised one hand and she stopped. I went to the kitchen and made a pot of coffee and sat at the table until her car and the other car were both gone. Maya was at a sleepover that night. I was glad for that. I called a man named Howard the next morning. Howard was not an attorney. Howard was a retired detective I had known for 15 years through the county union. We had breakfast together 3 or 4 times a year at a diner on Route 9, and I trusted his judgment more than almost anyone's. I told Howard what I had found. I told him about Sandra. I told him the name Gary Whitfield. Howard got very still. "How do you know that name?" he said. I told him Sandra had mentioned him repeatedly over the past year. Howard looked at his coffee cup for a long moment. Then he told me that Whitfield had been under investigation for almost 18 months, that the development projects were partially funded through a scheme involving inflated appraisals, fraudulent investor disclosures, and the misappropriation of funds from a federal small business loan program. The state attorney general's office was building the case. They were close. But they needed documentation of the financial flow that they had not been able to obtain. "Sandra manages his properties," Howard said. "She does," I said. He looked at me. "Do you still have access to shared financial accounts? Shared computer passwords? Anything like that?" I thought about the flannel shirt in my closet. I thought about Maya's drawings on the refrigerator. "Yes," I said. What followed was not dramatic in the way people imagine these things when they watch television. There were no wiretaps on my body. There were no midnight meetings in parking garages. It was mostly paperwork. Emails I forwarded from Sandra's shared laptop when she left it open. Statements from accounts she had asked me to monitor while she traveled. Records that meant nothing to me individually, but that, when arranged in a particular order by people who understood what they were looking at, told a story of approximately $4.3 million moved in ways that could not survive scrutiny. I signed a formal agreement with the AG's office in June. I was given a contact. I was told to continue behaving normally and to document what I could without creating suspicion. I was told, very clearly, that nothing I did should endanger myself or anyone in my household. I thought about Maya. I told them I understood. Sandra filed for divorce 11 months after I found her in the house. I believe she assumed I had simply been swallowing the knowledge and continuing on, which is what some men do. I believe she had decided to leave on her own terms, while she still controlled the narrative. She wanted the house. The house was the largest asset in our joint name, and it was the thing I could not let her take. I did not file a counterpetition. I did not hire a lawyer. I sat with the paperwork and I attended the mediation sessions and I said very little and I waited. I was waiting for a specific date. The mediation in the Harmon building was the third one. The previous two had stalled. Pierce had grown progressively less patient. Sandra had grown progressively more distant, which was a thing I recognized as calculation. She was watching me the way you watch something you expect to eventually collapse under its own weight. At the second mediation, Pierce had made a remark about my truck. I drove a 2009 F-150 with 212,000 miles on it. He had said, and I remember the exact phrasing, "Mr. Calloway, I say this with respect, you don't appear to be in a position to maintain a property of this value." He had looked at my boots when he said it. I had looked at my boots too. They were work boots. I had resold them twice. "I manage fine," I said. That had been the extent of my response. Pierce had glanced at my wife and she had looked at her phone. At the third mediation, the one with the moth sound light, Pierce had prepared a valuation of the Dunmore Lane property and a proposed division of assets that would have given Sandra the house, 60% of my pension payout, and a lump sum I would have needed to liquidate savings to provide. He walked me through the proposal the way a man walks a child through something obvious. "Given your age," he said, "and the limitations of your retirement income, there may be some appeal in simply resolving this cleanly. The property is more than you need. A cash settlement would give you flexibility." I was 63 years old. My granddaughter was 9. She had a room in that house and a bicycle in the garage and a second-grade teacher who knew her name. "I appreciate the proposal," I said. Pierce blinked. "Does that mean you're accepting?" "It means I appreciate it," I said. Sandra turned toward me then. It was the first time she had looked directly at me in 3 sessions. Her expression was something I had never been able to read on her face while we were married, and I realized sitting there that this was because it had not been directed at me before. It was contempt, pure and uncomplicated, the way a primary color is pure. "Tom," she said, and then she stopped, because there was nothing after it. She had said my name the way you say the word done. I looked at the light on the ceiling. The mediator, a patient woman named Elise, who had been trying to find common ground for 3 sessions now, suggested we take a 15-minute break. I went to the hallway and stood near a window that looked out onto the parking lot. My truck was down there. A crow was sitting on the tailgate. I watched the crow for a while. It had the unhurried quality of something that had decided the day was going well. My phone buzzed. It was a message from my contact at the AG's office. 3 words. "Tomorrow, 9 a.m." I put the phone in my pocket and went back to the conference room. The hearing was in courtroom 4 of the Harrington County Courthouse. I wore the flannel shirt. I had considered, again, wearing something else. My daughter had called the night before and asked what I was planning to wear, and I told her, and she was quiet for a moment and then said, "Dad, maybe wear the gray jacket." "The flannel is fine," I said. "You look like you're going to fix someone's breaker box." "I fixed a lot of breaker boxes," I said. Things generally went well. She exhaled in the way children exhale at their parents. Then she asked about Maya, and I told her Maya was at school and doing a project about the water cycle and was very invested in the evaporation segment. Claire laughed despite herself. We talked for another 20 minutes about nothing in particular, which is the best kind of conversation. I drove to the courthouse the next morning and parked in the lot on the east side. I sat in the truck for a few minutes with the engine off. The crow was not there. It had presumably moved on to better tailgates. I went inside. Pierce was already seated at the plaintiff's table when I walked into courtroom 4. He had a leather briefcase and a charcoal suit and the particular posture of a man who has won this specific type of case many times. My wife was beside him. She was wearing a gray blazer this time and her hair was up. She had dressed for resolution. I sat at the respondent's table. Alone. Pierce looked at me. Then he said something to my wife in a low voice, and she pressed her lips together and looked at the front of the room. Judge Marlene Fossey came in at 9:07. She was 61, had been on the family court bench for 14 years, and had the specific demeanor of a person who has seen every human failing available and has made her peace with the catalog. She reviewed the case summary and asked if there were any preliminary matters. Pierce stood and noted that the respondent remained unrepresented. "Mr. Calloway," the judge said, "you understand you have the right to counsel and you've waived that, right?" "Yes, Your Honor." "All right. For the record, please state your full name and your current occupation." I looked at my hands on the table. Then I looked at the judge. "Thomas Edward Calloway," I said, "retired county electrical inspector, and currently a sworn confidential source for the Office of the State Attorney General." The room did not go quiet all at once. It went quiet the way a sound system goes quiet in stages, the last frequency fading a half-second after the others. Pierce had stopped writing. I watched his face move through several expressions in the space of 4 seconds. Recognition came last, but it came completely. His pen was still in his hand, but it was not touching the paper. My wife turned to look at him. He did not look back. Judge Fossey said, "Mr. Calloway, could you repeat that last part?" "I am a confidential source for the state AG's office," I said. "I've been providing documentation in an ongoing financial fraud investigation for approximately 14 months. I understand there may be proceedings today that intersect with that matter." The judge looked at me, then she looked at the back of the courtroom. I had not turned around. I turned around now. There were 2 men standing near the rear doors in dark jackets. One of them held a folded document. They were not bailiffs. They were not court staff. One of them made eye contact with Pierce, and whatever passed between them drained the color from Pierce's face in a way that had nothing to do with the fluorescent lighting. "Your Honor," one of the men said, stepping forward and presenting credentials, "we apologize for the interruption. We have a warrant for the arrest of an individual who is present in this proceeding in connection with a federal fraud and conspiracy matter. We'd ask the court's cooperation." Judge Fossey looked at the credentials. She looked at the warrant. She looked at the room with the measured attention of someone who has learned to process the unexpected without performing surprise. "Counsel," she said to Pierce, "step back, please." Pierce stood very still for a moment. Then he did something I had not expected. He sat down. He placed both hands flat on the table. He said nothing. The compliance in it was total and immediate, the compliance of a man who knows that movement has already ended, that the only question remaining is degree. Sandra's voice came from beside him. "What is happening?" "Pierce, what is happening?" He still did not look at her. The agents walked forward. There was a brief, quiet exchange near the plaintiff's table. There were words I could not entirely make out. And then one of the agents said, in a register that carried clearly, "Sir, you'll need to come with us." Pierce rose. He straightened his jacket out of reflex. He walked toward the rear doors without looking at anyone. My wife watched him go. Then she looked at me for the second time that morning. She looked at the flannel shirt. She looked at my hands. I did not say anything to her. There was nothing in the room that required my words. The case was continued for 60 days. My wife's legal position became significantly more complicated in the weeks that followed, for reasons that had nothing to do with the divorce proceedings directly and everything to do with them. Her professional relationship with Whitfield came under scrutiny. Documents I had provided outlined the role she had played as property manager in routing funds through accounts she controlled. She was not arrested, not immediately. Her cooperation with investigators in the weeks following Pierce's arrest altered her trajectory. What she gave up in the process of cooperation included, among other things, the legal strategy she had been planning to employ against me. The claims against the house at Dunmore Lane were withdrawn. I signed the final divorce papers on a Wednesday afternoon in November. I sat in the parking lot afterward for a few minutes. It was a cold, gray day, and the bare trees along the lot edge had a particular dignity to them, the dignity of things that have shed everything unnecessary and are simply standing in their own shape. I called my daughter. "It's done," I said. She was quiet for a moment. "How do you feel?" I thought about it. "Quiet," I said. "I feel quiet." She cried a little. Not dramatically, just the small, relieved kind of crying that sounds like the end of held breath. She told me she was proud of me, and I told her I did not know that there was much to be proud of, that I had mostly just paid attention and waited. She said that was exactly what she was proud of. Maya was home when I got back. She was at the kitchen table doing math worksheets, her pencil working across the page with the concentration of someone who has decided that 3-digit multiplication is a reasonable challenge for a Thursday. She had her mother's nose and Ruth's eyes and a way of holding her pencil that was entirely her own. I sat down across from her. "How was school?" I said. She looked up. "Good." We started fractions. "Fractions are important. They're annoying," she said, with the precision of a 9-year-old delivering a legal opinion. "They are both," I said. She went back to the worksheet. I made dinner. We ate together at the table that had been in the kitchen for 11 years, under the light that I had installed myself, the spring after Ruth died, because the old fixture kept flickering and I could not stand one more thing in the house that needed fixing. My daughter asked me, some months later, what the hardest part had been. She asked it seriously, the way she asks things when she actually wants to know the answer. I thought about it for a long time. It was not the discovery, I told her. It was not the decision to contact Howard or the 14 months of documenting and waiting. It was not the courtroom. The hardest part was the period in the middle, the long stretch of ordinary days where I was living inside a secret and going to the grocery store and watching Maya do her homework and making coffee in the same kitchen and carrying something that no one around me could see. The weight of that was not dramatic. It was just heavy, in the way that constant things become heavy. "But you kept going," she said. "There wasn't really a version where I didn't," I said. She thought about that. "Because of Maya?" "Partly," I said. "And partly because the thing that was happening was wrong, and I was in a position to do something about it. That's not complicated. It's just arithmetic." She looked at me for a moment. She has her mother's way of looking at people, the way Ruth had, where you feel seen in a way that is not entirely comfortable but is entirely trustworthy. "I love you, Dad," she said. "I know," I said. "I love you too." The house at Dunmore Lane is a 3-bedroom colonial on a lot with 2 large maples in the backyard. In October, when the leaves come down, the yard fills with them and they have to be raked. Maya has strong opinions about the raking and assists in a capacity that she estimates to be 50% but that I would put closer to 20. She is also the one who, in the midst of the raking, proposed that we make a pile specifically for jumping in, which is a separate matter from the raking itself and should not be counted as productivity. I agreed to this. After, when the pile was destroyed and the leaves needed to be re-raked, she looked at the mess with satisfaction and said, "Worth it." I looked at the yard, at the house, at the maple trees that were older than I was and would be there long after neither of us could see them. "Yes," I said. It was. I picked up my rake. She picked up hers. The afternoon was cold and clean, and the sky was the specific blue that only comes in late October in places where the seasons are real, the blue that looks like it was put there on purpose. We raked until the light went.